we are going to make a start. It has just gone 5 o'clock, so if we could just continue, Adele, I think just leave it be as you are. I think it's fine. So,
That's fine.
Yeah, perfect. Thank you. That's good.
Okay, good.
All right, everybody. Good evening. Welcome to our webinar for July. My name's Andrew Schaefer from Trafalgar, based in the Johannesburg office. If I could just introduce my colleagues joining me this evening. Left to right on my screen, I have Adele Reinecker, who's a National Collections Manager at Trafalgar. Adele is an admitted attorney with many years of collection experience. Kirin Kutsia is our regular facilitator and organizer. So Kirin is here from Cape Town and our National Property Management consultant and divisional lead. Peter Menon, Director of Trafalgar, also admitted attorney, also many years of collections experience. Our topic this evening is all around collections, collecting arrear levies. It is an important topic. It is close to the hearts of many of our clients, directors and trustees who are, frustrated, challenged, worried about arrear levies and the complications of collecting arrear levies, and in particular, what the legal process involves, how to accelerate it, how to do better with legal collections. Also, many small, medium schemes are often challenged with cash flow issues with a small number of owners who may not be paying their levies, and this can cause complications with paying for maintenance, municipal costs, even the legal fees to progress the legal process. So it's a really top priority topic. We hope you find the discussion interesting tonight. There's some new thinking in the space, and we are going to give you some insights into some new ideas around effective debt collection, which we hope you will find interesting. We will be aiming to complete promptly by 6 p.m. If you have any questions, please do raise those in the Q&A. We will be answering as we go. A reminder that we will circulate the slides as well as the recording link for this webinar to all those that have registered. You don't need to ask for it. It will be there for you. Another reminder that all of our recordings are on the training website. Trafalgar's training website is training.trafalgar.co.za. Our last 3 years of webinars are all available there. They cover a variety of what we think are relevant and important topics. They're good for refreshers. There's multiple training courses. It's all free on community schemes, sectional title, homeowners associations. Kirin is available for questions or to support any of the training. And it certainly should be very useful to anyone who's new to a trustee or director role and would like to know more about being involved in managing community schemes. So just a reminder on that. There'll be a short survey popping up at the end. For those of you that have 30 seconds, we would appreciate your brief feedback on how you found the webinar, in particular, any options to improve, and then any topics you'd like us to cover going forward. It's a good place to make any suggestions, and we will endeavor to respond to, the needs that are expressed there. So if you wouldn't mind doing that, we would be very grateful. Our next webinar will be on the 28th of August. We will send out invitations in advance to our mailing group. The topic is going to be on a very detailed and insightful CSOS practice directive, which gives a lot of good guidance on managing disputes and other challenges in community schemes. We think it will be really interesting for those of you that do like to be informed about community scheme matters. Peter will be facilitating that with a specialist attorney, and it does give, some very good clarity in the space, which has been lacking before. So that's it from me. Welcome once again. Thank you for your time. And I'm going to hand over to my colleague, Adele, who's going to start us off this evening. Thank you, Adele.
Thank you, Andrew. Okay, welcome everybody. So we're going to start off our show for you tonight with the importance of effective debt collecting. Now, we always get this question, why do you pay levies? And your levies stem from your ownership in a community scheme, may that be a body corporate or a HOA. If you're in a HOA, it comes from the Sectional Titles Act, that you have to pay your levies. And if you're in a HOA, it comes from the MRI that you form part of when you become an owner. Okay, so you pay your levies because of shared amenities within these community schemes that you have, as well as shared maintenance. There is the shared areas that you have access to, and then those upkeeps of those areas needs to be paid for. Now, a further expense that is paid for by your levies is, of course, then in terms of regulation, your reserve funds, and then also your municipal accounts. Now, from experience, we found that if body corporates do not make appropriate provision in their budgets for taking care of their municipal accounts and increases, and this is now either in terms of the entire scheme or it might be the common property area, then these municipal accounts can creep up, become unpaid due to owners that do not pay their levies, and they become a massive problem and a bit of an unforeseen expense, especially because of our increases in municipal rates that go up each and every year. So this is one point that we do like to highlight, that body corporates and HOAs need to cater for, because this can be a downfall. The municipalities simply do not care that you do not have money. They will come and cut your services, your water, or your electricity if it is not paid. So that is a very important point to take care of. Then your service providers. You have to pay your plumbers, you have to pay your securities. If you have any special projects that you want to incorporate in the property, like for example, you want to put up an entertainment area for kids or a play area for kids, all these types of projects needs to be funded, and they are funded through levies. Can we just go to the next slide? Now, the consequence of non-payment, as you can imagine, it has all of these items that we just discussed has an effect. So your financials will firstly be in a state you will not be able to pay your municipals, you will not be able to pay for all the services that you are supposed to cater for to the owners in terms of the levies that was raised on your budget. So there's a massive effect to the community scheme, and at the end of it all, your body corporate loses value. And through that, your property, which is most probably your biggest asset you have, that loses value due to other owners that do not pay their levies. Now, I like to say this to all our clients. It is part and parcel of owning a property in a community scheme that you deal with non-paying owners. None of the schemes are exempt from it. Every scheme sometimes have either a few non-paying owners or just some non-paying owners, but it comes with the territory. Now, that is not supposed to give owners in community schemes with high arrears solace, but it is just stating the fact that this is how schemes work. You do not have control over your neighbor's finances. You do not have control over whether they have a business that fails and cannot pay anymore, or they get fired, or they become deceased. So those are all items that you have to deal with as an owner within one of these properties. Okay, we can move on to the next slide. Now, the big question here is, what is a body corporate to do? Now, we, as managers of body corporates, we like to say that you cannot take the law into your own hands. So while we are a community, while you are in a community scheme and you sit with fellow owners there, you cannot simply come there with pitchforks and say, okay, you are voted out. We don't want you there as an owner anymore. We have to use the tools to our disposal. You have the courts and you've got the legal system. And then obviously you also now have CISOs. My colleague Peter Menon is going to take you through CISOs in a moment and what is to the disposal of owners and community schemes that want to use CISOs. But we are now going to go further into the legal process, because one of the questions that we get from our trustees and owners alike in body corporates where there are arrears is, why does the legal process take so long and why is it so expensive? Okay, we can move on.
Adele, can I stop you there for 1 second? I'm just going to stop share and ask Peter to start sharing, because apparently there's something going wrong with the way I'm sharing.
Yes, there is a bit of, there's dark blocks on the screen. No problem.
Okay. Okay, I'll stop. Peter, if you can start.
Certainly, Adele, you can just continue for us, please. I'm just going to share from my side. Thank you.
Okay. So what I want to show us is just a bit of an example of the timelines we are sitting with and the pitfalls we have when proceeding with legal action. Now, at Trafalgar, we have a very strict debt collection policy that when owners go into arrears with 3 months of levies, the legal action is the next step that will follow. So once the internal debt collection has stopped, meaning whether you are with any managing agent, once a letter has been sent, once you as the owners have contacted the non-paying owner and explained to them there is arrears, and you decide now this is now time we are proceeding with legal collections, this is the steps that will follow, and this is roughly timelines that we have put together just to give you an indication of what we are dealing with, to understand why it takes so long. Not everybody is attorneys, not everybody likes to be litigious and knows how these processes work. So we want to keep you as an owner in a community scheme informed, okay? So once your debt collection has stopped and the matter is finally handed over to the attorneys to proceed, this is where a letter of demand is sent. Now we have to send that letter of demand due to the court's first question will be, when you bring a summons before them, is, but did you give enough notice to this owner that you will be proceeding with legal action? And thus, a letter of demand is sent, a 3-week period is given to the owner to be made well aware thereof and to remedy any non-payment from their side or to enter into payment arrangements. Now, sometimes this is good enough to give an owner a good scare and then they start paying, they enter into payment arrangements, they miraculously get the money somewhere because they don't want a judgment against their name. This remains on their credit score. This has an effect when they apply for jobs, when they apply for credit. So owners are made aware of this within this attorney's letter, that this has a big effect on them as a person. So from there on, once that letter of demand has lapsed, the second step will be to issue a summons. Now, this is where the attorneys draft up a summons. Therein, it would explain exactly why this owner is arrears, goes to court, comes back. The sheriff then needs to serve this document on the owner. Now, sometimes you don't know, perhaps the owner doesn't live in the unit, he's got it tenanted. So that can take up to a month, even more, dependent on whether you get proper service. And remember, if you do not get proper service, the court will and can easily tell you to go back to get proper service. So these pitfalls, and that is why it is also very important to get an attorney that specializes in debt collection at least, and it is even better to get an attorney that specializes in sectional title debt collection to assist your body corporate and community scheme in collecting these arrears. Because the courts and their rules and their directives are constantly changing, you can't simply, horses for courses, you can't get your divorce lawyer to come and start doing collections at your body corporate. It's simply not the best practice, and we would not recommend that. Trafalgar does have a panel of attorneys that does work mostly for all of the schemes, and they provide an excellent service with years of experience in performing debt collection and litigation against defaulting owners. Now back to our slide there. So you will see that you are now at round about 2 months in, you don't have a judgment. You can only start executing once you have a judgment. Now, if the owner doesn't defend, and owners do not defend, most of the time do not defend these actions because they are well aware the levy is due and payable. So if the owner doesn't defend, we proceed with a default judgment. Default meaning they defaulted to defend, thus we are applying for a judgment. Once you have that, and it can take, in some courts, 6 weeks, other courts up to 6 months, to get that default judgment for 3 months worth of levy arrears, because that is for what the summons was issued for. Then you have that judgment, and this is now where the execution process starts. Now you will see the timelines there, and I know we don't have all the time in the world, so I would recommend that when these slides are shared, you can in-depth go through each and every item here, but I am just going to move along a little bit quicker now. The next step will be, again, to go back to court, get a warrant. This is an instruction to the sheriff for the sheriff to proceed with then attaching movable goods. Once they've attached those movable goods, you can then proceed to sell those movable goods. And that means it's a fridge, it's a bed, it's the plastic chair, it's whatever you can find. Sometimes it's a Smeg fridge. So sometimes you're lucky and you can actually get enough funds from selling the goods to extinguish the debt and the legal fees that was forked out by your body corporate. So you can see it is not, at the end of the day, the courts are not checkers 60-60. You cannot go out and say and order, I want this and I want it so and I want it then and there. You need to keep in mind that it's a process, it needs to be followed, and court is not a place to mess about, because they will send you back. So at the end of the day, if you cannot then liquidate the judgment, you will then have to proceed. We can go on to the next slide. You will then have to proceed with executing against the unit. Now, this is the same process as when a bank forecloses. So they go after the unit to sell the unit on auction. But remember, there is lots of regulation, and I'm not here to take you through a whole course of the legal process, but please have a read through of what is required and the timelines involved. It is intricate legal work with lots of costs involved. In terms of appointing the sheriff, the sheriff's costs are a lot. If you have to appoint counsel, there's a lot of money involved there as well. So you will note that the last step is that you sell the property on auction. But however, if you cannot sell this property on auction, you will then have to proceed with sequestration or liquidation, whether it's the owner or a company that owns the property. And that will be your last step to try and get in the funds, because remember, your body corporate gets issues levy clearance, and levy clearance is paid up on transfer of the property. So that is why the goal, if the owner is a constant delinquent payer and keeps on not paying, is to eventually sell the unit via public auction, via sheriff's auction. If that cannot happen due to the arrears connected to this property being too high, then you can eventually then proceed with sequestration or liquidation. Okay. So the point that I wanted to make is that legal action is the tool available to the body corporate to collect the arrears, but it is very involved, and you need a good attorney. You need money to actually litigate and get the levies that is outstanding from the owner. Now, I know that we can move on to the next slide. I know that there is a lot of body corporates that sit with arrears, but they are now in a financial crunch where they're already not getting their full income for an amount of, let's say, years. So they're sitting with cash flow issues, and this is where Trafalgar can assist. This is exclusively for Trafalgar clients. We have a financing product called Levy Solutions. This is where your levies, historical debt book, arrears is then funded to the body corporate or the HOA, so that there's a big influx of cash flow to assist. Because a body corporate who has been in arrears for a long time definitely sit with a lot of issues like maintenance, as well as municipal arrears, cutting of the services. And this is where a product like this comes in. Also, your budgeted levies, as approved by at the AGM, is then funded to the body corporate on a monthly basis. So this means there's two types. There's two types of levy funding: the historical levies as well as the future levies in terms of your budget. The third leg of this product is then also to proceed with rigorous debt collection as well as litigation to get the arrears in as quick as possible, as cost effective as possible, using our set of very competent attorneys to proceed with litigation and get the funds back in as soon as possible. So it means that while your body corporate has to consider taking legal fees into account when they draw up their budget, in this case, legal fees will not have a direct impact on your cash flow, and you can use your cash flow as it was intended to be. And in this process, we recover the arrears that is due by your non-paying owners, as well as at the end of the day, then possibly also get new paying owners in. You can move on to the next slide. I think I've covered this as well. You can go on. Just one more. Okay. There's various items we need to check before your building can be considered, and that is you need to be a Trafalgar client, and then also have your levy resolutions, handover resolutions, that all needs to be in place. So regulatory, your building needs to be sound before we can consider this. Okay. It is also to rehabilitate your building and eventually move you off of the product. So we can move on. Another slide. Okay. So again, just simply the pros. The pros is your cash flow influx, your portfolio manager, your trustees, directors can effectively budget. They can draw up a budget and know that this income is secured, this income will be coming in. So it makes it easier to plan. We have our in-house experts that will be leading the litigation of the product, making sure that these arrears come in as quick and cost effective as possible. And then again, as I said, the legal fees. It is also quite flexible, and you can move off of this product with 1 calendar month's notice. Okay. Next slide. Then the cons, again, it's a financing product, so you need to keep in mind that there will be a financing fee, which needs to be considered in your budgeting, because this financing fee will be raised on a monthly basis, what is funded to you. And then rehabilitation is not guaranteed. And then, of course, legal fees, which cannot be taxed and which cannot be recovered from the owner, will then be recovered from the scheme. Okay, so this is just again how it works and how it can assist your building. You can move on from here. So just to end it all off, again, the legal proceeding with legal has its pitfalls, and this is why Menon is now going to take us through the CCILS process, because it is an alternative to legal to a certain degree. But we simply need trustees to act and be proactive when it comes to arrears, because you remember it's ever increasing each and every month. It will increase and it will have an effect on your building. Thank you.
So Del, before we sort of turn to Peter on the CSOS option and approach, won't you just talk about blacklisting? So when exactly does blacklisting happen, and why is it important as an additional lever to the collections process?
Okay, so firstly, the name blacklisting is partly frowned upon, and they usually want us rather to refer to adverse credit listing, because that is simply what it is. You are your credit listing basically says that we have given you notice, we have given you 20 days notice, and you have not remedied your breach, and you have not paid your levy as you should, and now you have the stamp that you are a bad payer with an adverse listing against your name. Yeah.
Good. So maybe, Adele, maybe just to sum up your your presentation, and you can comment at the end here, is that you lead debt collection departments, so the debt collectors do need to be registered with the Council for Debt Collector, Trafalgar 2, because we are collecting third-party debt. But the pre-legal debt collection process really involves a combination of telephone calls, text messages, WhatsApp messages, and letters, to do the best that the debt collectors can to collect those arrear levies. Those processes are under our control, and we do try best efforts in terms of reaching the debtor, making contact with them to remind them of the debt, to understand why they're not paying the arrears, and the whole push is to make a payment arrangement to help them bring their levy accounts up to date. Typically there's let's say a default, but buildings decide on what payment arrangement terms they're willing to accept, perhaps 6 months or 12 months to pay current, plus a portion of the arrears to bring the accounts up to date over 6 to 12 months. And that really is the drive of the debt collection department to do it. And then, when you got into the discussion of the legal process, and it was a good reminder of the steps of the typical turnaround times, maybe just to emphasize that certain courts, perhaps the courts in Durban and KZN, have vastly different turnaround times to other courts like in Johannesburg and Pretoria. So it very much is a regional timetable based on caseload, based on efficiencies. I think many of the listeners tonight will be aware that the courts had huge issues with backup energy, with utility supplies, etc. So there's lots of closures, lots of disruption, and therefore lots of backlog as well. But certainly the timetables do move a lot. They are different in different places, and they can be a lot longer than the averages you were explaining. But your timetable did give an indication of why it does take long, why it is expensive because of that time delay and all the legal work that goes on. And it was a good point you made that, experienced collections attorneys are very helpful because they are well versed in the process, in the arguments, in the templates and what's required, and to promote a favorable outcome on behalf of the community scheme. Adele, can you just end maybe just with some of the pitfalls you've seen? So, where could a case go wrong in terms of administration, documentation required to support the case? I'm thinking of reconciliations and resolutions, etc.
So resolutions is very, very important. If you do not have a proper resolution passed at a trustees meeting, at an AGM, and you want to claim a debt related to that resolution, you can be shown away. And even later on, even if it is granted by default, that owner can come back and on rescission say, but you didn't raise this levy properly. So having, we call it not your ducks in a row, but your docs in a row is a very, very good process, making sure that every document is properly signed. And that is where a good managing agent comes in, ensuring that these items are signed and kept for when we need it. We have matters where we have to issue summons for a person that hasn't paid his levy for 6-7 years. They come over to our management, and now we need to find all these resolutions related to interest, related to penalties and levies. So if that is not in place, how will we prove our claim? And CSOS will be the same. CSOS will show you a way simply because you do not have the documentation to prove your levy which you want to claim. A further element that is also unfortunately out of our hands, but it does occur, is when the owners have absconded, or there's simply a tenant in there. The tenant hasn't paid for years. The owners are overseas. You cannot get hold of them. It happens more often than you would think. This is where you would need extra steps like a substituted service application where you ask court, I cannot get hold of this owner, give me instruction on how I may serve on them. As I've said, service is a very important element of litigation. So you need to get that in order. That is a further step with further costs and further time that adds to it. So if I can just think off the bat, resolutions in terms of your managing agent being able to proceed with litigation on your behalf is also important. Making sure that you have given your managing agent the right instruction to say, yes, you can proceed and sign the affidavits on your behalf. Again, the courts are sticklers for details, but also only when it suits them. So those are the pitfalls that we see on a daily.
So, just to sum up then, I think a real reminder to all of us that the administration of raising levies and collecting levies is all important, because otherwise it could completely scuttle and lose a case, which is a great pity considering the time and the cost. And therefore, it's essential that the file is going to be complete, it's going to be sound, it's going to be well based, with that. So Adele was referring to a resolution entitling the levies to be raised on the 1st of each month, a resolution to raise interest, a resolution to hand over, and they also require a detailed levy account resolution from a zero balance showing each and every charge that's raised on the account, reflecting each and every receipt, and really breaking down the full arrears. If anything is missing in terms of those documents, the case could be lost. It literally will go back to the beginning, and that is a great pity. So, that is part of the role of the debt collection team, is to assemble a complete file to make sure that the attorneys who are instructed have the necessary documents and information, and that they can proceed accordingly with confidence and with what they require to have a favorable outcome. And Adele, last question, just comment on the fact that a summons is basically raised for a particular handover amount. You talked about 3 months, but, and it's important that the trustees are proactive and respond reasonably quickly so that this amount doesn't balloon over time, because the quicker there's a response and a reaction, the more likely there is to get a reasonable recovery. But what happens after 3, 6, 12 months? All the time this legal process is continuing, the levy arrears are growing. So
Yes.
what about, the arrears after the handover amount and down the line? What is your recommendation in terms of keeping up with the legal collections process?
So there would have to be a second, third, fourth summons. What we do is you get that first summons out. See, there's also a strategy behind litigation that is important, so that the instruction that hits the attorney is not just a blanket one, do what you want, just get it in. What we would usually do is get that first summons out, get that first default judgment, and then proceed with executing on that. But in that time, we've seen it takes sometimes 6 months, sometimes more. In that time, if the owner doesn't pay, and while we are obviously contacting them and in constant trying to get them to make payment, if they do not, we would issue a summons for a bigger time period, meaning possibly 6 months or 8 months. This means 8 months worth of levy will be a second summons. And that means that the owner gets a further judgment against them. And that is what you require to eventually proceed with possibly selling the unit on auction, because it would be ridiculous for you to issue a Rule 46 application where you want to sell the property on auction for 8,000 Rand. Then the owner is simply going to wait till the day of the auction and pay the 8,000 Rand and walk away. So you need how can I say, you need a big judgment to proceed with the further steps of execution. So unfortunately, you will have to go through the process over and over again if the owner simply pays the judgment amounts. Okay.
Good. And then just before going to Peter, just, the point of a pre-legal call, as the first step in that legal process, we find it so important that the attorneys make the call, make contact. Reaching the customer is so important. Tracing is an important enabler to that, but really just explains to them what is about to come in terms of a legal process and costs, and trying to be as persuasive as possible to preempt that and give them every opportunity to pay. And we find that a different voice from an attorney, with that intent in mind, makes a big difference in terms of expediting delinquent levy payers to pay. And that is critical and best practice in terms of starting off the legal process with that pre-legal effort and call. So
Yes.
Thanks very much, Adele. And we're now going to turn to Peter, who's going to talk about alternatives and alternative collection strategies and channels. Thank you, Peter.
Thank you, Andrew. Thank you very much, Adele. Good evening, everybody. Okay, so we'll be jumping into the alternative processes through CSOS and then heading into some illegal things that some people do on body corporates and HOAs and why these are illegal and what you can and cannot do. So with the CSOS process, and I know this is a lot of legalese being thrown at you on the page, but I thought we'd just at least add these into the slide pack so that you can read them after. But with CSOS, there are very specific prayers that you can ask for in terms of the CSOS Act, in terms of Section 39. Now, as you'll see in terms of Section 39E, an order for the payment or repayment of any contribution or any other amount. So you're going to establish your entire case, your CSOS application through 39(1)E. Interestingly enough, also, and I know this was a question in the chat earlier, you can also follow 39(1)C if there is a tenant or occupier in the unit, whereby it is a very big possibility that CSOS would order, 39(1)F, that CSOS would order that the tenant actually pays the contribution directly to the body corporate, akin to the rental amounts. So you can follow some pretty interesting nuanced procedure through CSOS, and I would definitely suggest this as an alternative method. But as you can see, there are very specific prayers that you can ask for in terms of the CSOS Act, and 39 is going to determine that for you. There's behavioral issues, scheme governance issues that you can follow as well. Meetings, management services, works pertaining to private areas and common areas, and then the rest as well. The reason why they've put this up as well is that CSOS has a very defined limited list of applications that you can bring and prayers that you can ask for in terms of Section 39. So you've got to structure it around that. CSOS and Adele has already gone through the legal process. And the legal process, unfortunately, through court or even through CSOS does take some time to do. What we've been seeing recently with our levy collections matters, they're taking between 3 and 6 months. There is a slide later on just explaining that CSOS is obviously increasing their capacity and their proficiency and efficiency, and we can see that on a day-to-day basis. But unfortunately, collections, whether you're going the legal route or the CSOS route, takes time. The positives about CSOS, however, is that it doesn't cost a cent in legal fees. It's a free process to be utilized, that you can take, and you will, at the end of the day, get satisfaction as much as the courts. Even though this would not be considered a court order, you would need to take further steps thereafter. I actually excluded some slides tonight that specifically went through the process of making a CSOS order an order of court. But that can be done through an attorney after the fact once CSOS has granted an adjudication order for you. Should you require a copy of the Act, we can also make that available for you. Corinne can send that through the email as well after the slideshow and the presentation. So as I mentioned, you've got to go through Section 39. You're going to go through Section 39(1)E, file that through the application process. And then CSOS, if there aren't any very specific defenses, would usually grant an order for this. And it's a lot less of a formal process than what you would follow in terms of your court process as well. Current CSOS status that you're going to follow is Stage 1, your conciliation, Stage 2, your adjudication, and then Stage 3, your appeal or enforcement of the matter. I'm also not going to take you through all of these slides. Brendan did a fantastic presentation for us last month on the CSOS collection procedure and also different matters that you can take through CSOS. If you're interested in that recording, it is available from the blog, as Andrew mentioned, news.trafalgar.co.za. They're also available on the YouTube channel as well. So you can go and have a look at this. Brendan takes you through each and every single step in detail. But at the end of the day, conciliation is conciliation. It's mediation between the parties. A conciliator at CSOS sits everybody down through teams You go through the documentation that's been submitted by the applicant, as well as the defendant, if there is a defense. And hopefully through that process, the respondent actually decides that he is liable for the levies and makes payment thereafter. Usually we stop at this process unless there is some very good defenses by the respondent. And should there be any defenses and you not be able to reach agreement through the conciliation process, the next step that they're going to call for is adjudication, which usually gets called 7 days after the conciliation process has ended, where you haven't reached agreement. This is more of a formalized process. There's been instances where they declare the matter purely based on the documentation. If there's no real defenses raised in terms of the documents, sometimes they require you to have an in-person meeting after the fact as well, that the matter is discussed and that the cases are presented on both sides. At this step, should you be successful, an adjudication order will be awarded after this process has been followed. And then stage 3, your appeal or enforcement. Once an adjudication order has been granted, the matter can be taken through to the High Court to be made an order of court. This is a pretty simple process whereby you can contact an attorney. We've also got a sheet from Saronio attorneys if you're interested to show you exactly how that process flow works. It does take a little bit of time, but at the end of the day, that adjudication order is going to hold as much weight as what a High Court order would if you're following the normal process through an attorney. The structuring of CSOS, as I've mentioned, there's some fantastic things happening at CSOS. Really, we've actually today launched our newsletter at 12 o'clock this afternoon. If you're interested in that, you can sign up for the newsletter as well. Corinne can take down your details. It's also available directly through the newsletter and our social media channels. But we've actually commended CSOS over the last year or so with the processes that are being followed. They are engaged with NAMA, they're engaged with different service providers as a result of the professionalization of the industry through the Property Practitioners Act, and us as managing agents now having to be registered through the Property Practitioners Regulatory Authority like an estate agent would. They really have come to the table. And as we're going to be discussing a little bit later on as well, there's new consolidated practice directives out that took them ages to compile and complete, and some really interesting things in there that is really going to assist the industry at the end of the day. But they have appointed more adjudicators to handle the matters. They see that there's a huge backlog in courts, so they want the managing agents and the body corporates, of course, to take the matters through CSOS when it comes to matters specifically pertaining Section 39 and all of those orders that they can declare. So really all kudos to CSOS at this point in time. They're doing a fantastic job. If you're interested in Brendan and Brendan's details, he works for Trafalgar as a community scheme manager in the Johannesburg branch. However, he's got a secondary function in that he is running one of our smaller subsidiaries called the Community Catalyst that deals specifically with CSOS disputes. So anything from collections through to real problems at the body corporates or HOAs, Brendan can assist you with that. And I've put his pricing on the slide deck as well for you to utilize. Illegals, the interesting part of our conversation tonight, what you can and cannot do. Andrew, I'm going to start with some legalese again. I apologize, but it's important because we need to understand where this comes from. We need to understand why things cannot be done in a certain way at a body corporate or HOA. And the real principle behind this is a common law principle called the mandement van spolie. In layman's terms, it's usually referred to spoliation in the court. And I'm going to just quickly take you through the legal definition of what the mandement van spolie is. So basically, it is the requirements for the mandement van spolie is peaceful and undisturbed possession of a thing. and the unlawful deprivation of such possession. So what that means is if a person is in undisturbed and peaceful use of something, you cannot, other than through a court order, deprive that person of that peaceful use and enjoyment of that thing. And this really is very far-reaching. It touches on things like corporeal property, which is property such as your unit, your physical bricks and mortar, and also touches on incorporeal property, which is things like electricity use, Wi-Fi use, and water at the end of the day. A lot of the time when we're talking about spoliation, we're talking about robbing somebody of use and enjoyment of something. And a lot of these principles are also contained within our constitution, that you cannot unlawfully deprive somebody of useful or peaceful and undisturbed use and enjoyment, similar to a situation with a lease agreement, where you cannot just evict somebody without a court order. You need to follow the court process, which does take long, similar to situations like this. It's also called taking the law into your own hands. So depriving somebody of that useful, peaceful use and enjoyment would be taking the law into your own hands, which you can't do. And disruption and disconnection is seen as exactly the same thing. So whether you're disrupting something partially or whether you're disconnecting completely, it's all contained within this common principle of the mandement. So a couple of actions and examples that we see on a day-to-day basis is service disconnections, things like electricity and water, or at least limiting the electricity and water. Other services and amenities, things like garden services or refuse removal, access, visitor access, maintenance on the property that's being withheld, and just in general making things difficult. Now, obviously, and Corinne is probably going to hate me for saying this, I apologize, but certain of these actions that body corporates and HOAs take is a lot more risky than what other actions would be. So let's say, for example, disconnecting a person's electricity or water is very high risk, whereas limiting access or making things difficult at the access points, let's say, for example, disconnecting tags and whatever it might be, still falls within the definition of spoliation within that mandement. However, there's a lot less risk inherently involved in that process. I'm not saying do it. I'm saying that there is a lot less risk involved when it comes to processes like that. All of them are incorrect. You can't disrupt, you can't disconnect, you can't make life difficult. At the end of the day, there's only one process to follow. One of the Paddocks articles that I read this afternoon just on this matter as well, and Graham gives a very good, let's say, way of dealing with these things, is let's talk just about electricity and water. Make sure that there are individual prepaid meters at the premises. It's going to curb the situation where you are billing water and electricity through the levies and the tenant doesn't pay so. So it's a much better way of actually handling those and ensuring that you don't have massive arrears when it comes to your municipal services at the body corporate or HOA. But I'm just going to reiterate that all of these things are illegal. You can't do it. Then, oh, sorry, I didn't actually include these. These are the process steps to follow to make an application or an adjudication an order of court, and these are part of your slides, but we can send it separately should you like that as well. See, we're running out of time, so I'm going to rush through this. I apologize. Consolidated practice directives. I've already given TSOS a lot of acclaim through this talk, but it really is an excellent initiative. There's a real consolidation and clarification of all the previous directives. So CSOS released a bunch of different practice directives when it came to processes that need to be followed, what you can do at CSOS, what you can't do, the conduct of the adjudicators. But they've really done a great thing here in that they have declared certain rules in your management or conduct rules undesirable, that cannot be included. And they've given examples of that through the Consolidated Practice Directive. As Andrew mentioned, we are going to have a webinar on the 28th of August with HB Incorporated, who did a really nice summary of the Consolidated Practice Directives that was featured in our newsletter and is also available on our blog if you want to go and have a look at that. And CSOS is also going to be joining us for the talk on the Consolidated Practice Directives. Furthermore, CSOS is also running a couple of sessions through NAMA and then through the Paddocks Industry Summit, which begins tomorrow, that Andrew and I will be panelist presenters on as well. CSOS is going to be there to discuss these Consolidated Practice Directives as well. Chapters 4 and 5, most important with dispute resolution, and really just speaks to how disputes must be managed within body corporates and HOAs. And the process that we've discussed already as well has just really been clarified and tweaked in terms of these new practice directives. One very interesting one, me saying that disconnection of utilities is illegal, is one of the undesirable rules that they've put in. Let me just quickly read this and see how this has been worded. Any rule that seeks to restrict and or disconnect water and or electricity supply to members due to non-payment of levies is not undesirable. So that means that you can write rules into your conduct rules that says that you can do it. But if you read a little bit further, it says due process must be followed by the body corporate prior to the disconnection of utilities. So you can write it in the rules, but you can't actually do it. So it's sort of a threat through the rules, how I see it. But you must still follow that process. I just wanted to point this out because it really does give practical examples of what you can and cannot do. Thank you, Andrew. I think we can move over to the Q&A. I think we've got a couple of minutes left.
Yeah, excellent, Peter. Thanks very much. So, there's a lot of content on these slides. Please don't worry about anything you've missed. The slides will be circulated to pick up on any details you'd like to go back to. And, we'll show our contact details on the next slide. Maybe you can bring those up, Kiri, now. And, any of us are available for any specific questions or specific scenarios or circumstances that you're dealing with. And we're very happy to give feedback or input or advice as best we can based on our experience. Peter, so, what you're saying is that CSOS is a very realistic, a very practical and a growing channel in terms of area levy collections. Based on growing capacity, they're adding adjudicators to their panels. They are trying to catch up the backlog. Typically the orders are clear and they're enforceable then, as a high court order if the owners choose not to pay at the adjudication order stage. And we see that trend progressing in a positive way. Is that the takeaway?
100%, Andrew. I really believe that this is the new conduit for collections. There are definitely instances, and Adele will definitely agree with this, that the legal process is an absolute must. If there are very high arrears that you're dealing with, follow the normal legal route. But when it comes to day-to-day collections, small arrears that you can take through this process, I definitely think it's a viable option. And I really hope that it becomes more and more viable, more and more successful as the coming years progress and as they consolidate and really just work this harder.
And Peter, just if it is a high arrears and one goes the CSOS route and gets the order, would you need to then continue through the High Court for that sort of Rule 46 application to proceed with all the enforcement thereafter?
100% correct, Andrew. It would purely be the stopping point of judgment being granted. I think there was about step 3 or 4 in Adele's slides that she took us through. The rest of the processes will still need to be followed, those legal fees paid, and the attorneys appointed to follow that process, correct?
Yeah. Okay, so we're coming to the end of our time, but the point is, I think we're saying that the CSOS process is available. It's pretty much free. There's a very small admin fee that's paid. It's fairly simple. Trustees and directors can follow itself. If not, managing agents have capabilities to support that for you. Brendan Beach, performs that on behalf of Trafalgar. And, typically it should be faster and far cheaper than those first 3 or 4 steps of the legal process. We are seeing very often owners do decide to opt in to pay their levies because they can see the writings on the wall, that it is being escalated, that there is, a credible enforcement process going on. And then in the event if that is not successful, then the legal process can be continued anyway in a reasonably seamless way. So that's good to know. And, as Peter's clarified, the disruptions of services, which, we concede are effective, they are chosen by many trustees and directors to be applied to persuade owners to catch up with their levies. It does work, but it is important to be conscious of the risks and, to backtrack quickly if an owner does make a spoliation application. So there we go, the contact details. Again, you're very welcome to make contact. Audrey Lee was not able to join us tonight. She is unwell, but she is available for any questions or support that's required as well. So once again, thank you for joining us tonight. We appreciate you being here. If you are able to complete the survey, we appreciate that. And then we look forward to you joining us again on the 28th of August for the CSOS Practice Director discussion. Thank you very much. Have a good evening and appreciate your time. Good night.